The Buzz with Jess Lujan.
Good evening, Guam. I'm Jess Lujan. Welcome to this episode, the first episode of 3 episodes, where my guest, of course, will be the Guam Attorney General, Liz Barrett Anderson. This segment will be talking about Guam's plebiscite. So alongside Guam's Attorney General, Elizabeth Barrett Anderson, is Julian Uggan. Actually, we know him from not only the plebiscite case, but also the medical marijuana case. So good evening, Attorney General and Attorney. How you doing?
Good
Both
evening,
attorneys.
Jen, we are.
Thanks for having us.
Former judge, former...
quite a lot, and still hanging in there.
There we go. But anyway, so the plebiscite, where are we at with this? And Attorney General, in regards to, what do you think again on the legal arguments that Mr. Davis has put before the courts?
Well, I've been asked that question quite a few times. The case is now back to Guam. The Ninth Circuit has sent the matter back. The judge here on Guam was reversed. I actually believe that the federal judge's decision here was absolutely correct. However, the Ninth Circuit disagreed, and we have since the case has been brought back. It's been set for trial for July of next year, but this is not a case that necessarily goes to trial on the merits. So we have filed, and Julian is a Special Assistant Attorney General, and we brought him on board because of his expertise. And we have filed a motion for summary judgment, and that was filed, was that October or November, Julian?
October 30th.
October 30th, and all the briefs are now in, and we're just waiting for a hearing date. Hopefully it'll be sometime in
Now, let me
June,
get it straight, because,
January.
okay, as a layman. And,
I know I'm talking a lot of legalese.
As a layman, my understanding on Mr. Davis prevailing in the appeals court, the Ninth Circuit, in the sense, just basically it said to come back to Guam, says, hey, listen to this guy. Listen to what he has to say. Is that pretty much in layman's terms?
It's very hard when you have two lawyers to be able to talk in layman's terms. I think, Jesse, that's probably a good way of depicting what the Ninth Circuit said. We're sending it back. We want the court on Guam, the federal court in Guam, to hear more argument on it. Because the issue was before, here on Guam, the case was not ready.
Sure,
it's called not right, but it wasn't ready. And the Ninth Circuit said, no, we think the case is ready for argument. So that's where we're at right now.
Now, Julian, you've been at this ever since, even before you became a lawyer. and so, it's not... I mean, it would be surprised if you weren't involved in the case, actually. But this being the case, now, Mr. Davis' argument was basically said there's discrimination because of his race. But from my read, and I served a little bit of time in the legislature, and we had some amendments in regards to plebiscite votes and things of that nature. But my read of what the law says was it's not based on race, but based on dates. And whoever was in Guam prior to 1950, and they weren't U.S. citizens then, and became citizens of the United States based on the date being here. You could have been black, you could have been Chinese, whatever you be. If you weren't a citizen, you became a citizen then. So it was based on that. So that argument is not really race-based, huh?
Yeah, true. Actually, that's the heart of the entire case. His central claim in this lawsuit is that the statutory definition that the Guam statute employs, native inhabitants of Guam, is essentially a race-based classification and therefore violates the 14th and 15th Amendments to the U.S. Constitution. And our argument clearly, first and foremost, is that native inhabitants of Guam is not actually a race-based classification. Instead, as you've well put, it's a temporal classification, or purely about time and space. Whether a person happened to reside in Guam and was extended formally U.S. citizenship by virtue of the enactment of the 1950 Organic Act. And actually, the plaintiff, even in his pleadings, he openly admits that hundreds of non-Chamorros were made citizens by virtue of the Organic Act. So clearly, it's a multiracial, multi-ethnic group of people that comprise the native inhabitants of Guam. So on its face, the statute says nothing about it doesn't even use the word Chamorro. It says nothing about those. It doesn't actually preclude non-Chamorros from voting. It doesn't necessarily allow all Chamorros to vote. So in a pure sense, it's not a race-based classification. Yeah, go ahead.
Yeah, but that being said, because again, from my read, it's not race-based. But wouldn't his argument then fall more closely to the legal protection argument? In regards, all citizens have the right for protection and rights under the Constitution.
On the Voting Rights Act.
On the Voting Rights Act, yeah.
Well, this is not a Voting Rights Act.
Okay.
This is a vote, as many have said, could mean something, it can mean nothing. It's a political expression of a category of people at a particular time of 1950. Whereas the Voting Rights Act refers to the protection of all people to vote equally when you want to have a law passed, when you have a vested interest in placing somebody in office, and there's something that you can personally benefit from. But again, this is an expression, an obligation really of the United States to the people of 1950 and their descendants to ask the very simple question: do you want to continue to be part of this wonderful, great nation? Do you want to go independent, or do you want some other type of relationship, as we have with the Federated States, some type of compact of association? That's really what it is.
Now, there's argument in the previous Attorney General as well, and that started the argument as well in regards to this, and they said, but basically this lawsuit or this plebiscite basically is not a definitive action basically. Now, when you vote, it's not gonna, it's kind of like when we vote this November, okay? Whoever wins, the top 15, that's definitive. They'll be in office. 2 years from now, governor, whoever runs, definitive, who get the higher vote basically will become that. This is basically, it's not a definitive vote, it's a desire. It's a desire, it's what we want. Expression.
It's a political expression.
Yeah, but not necessarily, I mean, we still have to go get the okay. So in that expression, not being a definitive action,
Well, I like where you're going with the question, because actually it gets at the heart of another big problem with Davis's entire case, because there's an assumption being made the entire time that the 15th Amendment and the Voting Rights Act both reach the kind of expression that we're talking about here. This kind of non-binding, symbolic political expression is not actually prohibited by either the Voting Rights Act or the 15th Amendment. So we're saying, precisely as you've said, it's not definitive. It doesn't, like the Attorney General is just saying, it's not actually concretely changing legal relations among legal persons. So it's not installing any officers into any public agency, and it's not definitively deciding an issue of territorial law or policy. It's just an expression and a transmission of desire. The statute that Davis is challenging actually talks about that the only act that happens is that whatever is gets the majority vote, that desire is transmitted to the U.S. and to the United Nations. There's nothing else. What the U.S. does with that act is an entirely separate legal question. So that's why we believe, that he's wrong on the 15th Amendment and Voting Rights Act claims.
The United States could easily say, well, thank you very much, Guam legislature, this is a narrow expression of political view of a certain category of people, but Congress could say, we want everybody on Guam to be able to express this, and Congress could call for a full plebiscite vote, as they've done in Puerto Rico 3 times, and Puerto Rico just hasn't been able to get a majority for any type of status vote.
Actually, you've got 2 political candidates now saying, hey, we don't mind, if we're going to bail them out, might as well make them a state.
They're in some big trouble in Puerto Rico right now.
Big trouble. But so maybe let's not make reference to them, right? And so we won't be lumped
the
in.
big bear, as they call it.
There we go. We're going to pay some bills. We'll be right back. More about the plebiscite. Be right back.